Oh, Travis Wayne Goodsell. Back from my run. And giving you an update. And there's an update for you. Wow. It appears that after these 3 weeks of silence, that Judge Tina Campbell has authorized my brief that I had filed after my motion to recuse. They lodged the document. It says, document lodged consisting of 4 pages received from plaintiff. That was my brief that I submitted way back when, on November 4th. Because that's when they filed it, was November 4th, or I submitted it on November 4th, 2020, the day after November 3rd, which was the filing of the motion for Judge Tina Campbell to recuse herself. And so yeah, Friday, yesterday, the November 20th, at 10:20 a.m. Document lodged consisting of 4 pages received from plaintiff. Lodged, not filed. So you guys can't see that it was the brief that I submitted. Per 26 order, which number 28, the amended complaint also, I think is the actual one, where I complain that, hey, I didn't get a chance to even know she existed, and already she's sanctioning me with a censoring. She needs to recuse herself, but she's refusing and insisting on taking the case, and 3 weeks, nothing, after immediately shutting me down. And after I had filed her motion to recuse herself and the brief, which, when they didn't even put it on the docket, I got the point that they were going to screw me, and that they were purposely hesitating and delaying. And so, yeah, they say they didn't file it per 26 order. That's why it's called document lodged, rather than motion for or brief submitted. And so, attached document lodged for reference purposes only. No response required unless specifically ordered by the court. Let's take you into what that was. I think it's under this file. And it would be submission of brief. Submission of brief for November 2020. There we go. Bring up the Word document. Yeah, it was Chief Judge Robert Shelby, as I also submitted it to. The plaintiff herein submits the following brief. I'd already done this video reading it to you, but this is just a reminder since it's been 3 weeks. The plaintiff understands your order for the plaintiff to stop emailing your chambers. However, the plaintiff must report the court clerk's violation of the law and overriding your orders in the proceedings. And here they are, proving again they violated the orders. The plaintiff submitted 29 motion to recuse. That was the November 3rd one. Judge Campbell, 3 November 2020, which the court clerks lodged only the motion, but not the email, and claimed 26 order to ignore your Honor's overriding 28 order to have all submissions filed. As the plaintiff understands it, a motion for recusal takes priority over previous undecided motions. Judge Campbell can't refuse to hear a motion for her recusal for her upcoming decisions for the previous motions are in question, simply because the motion to recuse came after the previous motions, and she gave an illegal order to the court to deny subsequent submissions. That's Rule 11 with sanctions. She didn't follow Rule 11, which I found out after I did this. Judge Campbell is now expected to wrongfully decide in favor of the defendant on the previous motions, then deny the motion to recuse as moot, denying all substantive information from the plaintiff. Which this is substantive information, which they finally said they're lodging finally after 3 weeks for reference purposes only. The court is involved in gaslighting to protect the defendant. The plaintiff has the evidence to convict the defendant, but this court's compromised judges and clerks are denying and dismissing all motions and complaints before evidence can be presented. I'm pissed, but I'm keeping it under control. As a consequence, the fact that the defendant has the state of Utah indefinitely detained the plaintiff back in 2008 is now fake news and a hoax, with Judge Waddup's dismissal with prejudice in 219 CV 00711. And in this case, the court is desperately violating the law to deny the defendant's causing of the escalation of and science denial of the coronavirus, which is jeopardizing the plaintiff's life as a tampering in the 2 cases of the plaintiff. Now all of a sudden they bring it out after Nelson. See, Nelson, it was at 11 a.m. yesterday. He gave his little video thing. This was filed at 10:20 a.m. What the court is attempting to do is deny the CEO of the defendant, Russell M. Nelson, held 2 coronavirus cure religious fasts, which both obviously failed, and support other apostles who are publicly deceiving Mormons by telling them coronavirus is taking away their free agency and their religious freedom right to publicly assemble to worship, deceiving Mormons as to the defendant's causal actions, which resulted in Mormons' current lack of agency and religious freedom. See, now all of a sudden, document lodged for reference purposes. With the current escalation and indefinite condition of the viral crisis by refusing to shut down the defendant's religion and business facilities to save lives. The defendant is blatantly causing infection and deaths with their position of religious trust. What this court is attempting to do is deny that there is even a coronavirus pandemic threat, and that Governor Herbert and Governor-elect Cox caused the indefinite escalation of the virus in the state of Utah for their failure to follow recommendations of health professionals and their failure to follow through with their own preparations. Causal origins cannot be denied, dismissed, and ignored because it implicates the defendant and their co-conspirators in criminal actions. It is anti-justice, an anti-judicial process, an anti-science, and anti-scientific process. The virus will never be controlled or cured without a vaccine, and thus the plaintiff will never have justice with this court's corruption. Ta-da! For reference purposes only. The plaintiff is also in great need of submitting a brief about co-conspirators who are further attacking the plaintiff in regards to his residence. I found out in October, a month after I filed, that my landlord was plotting behind my back to have me kidnapped and moved to another facility where I would be imprisoned. Even after we went through all the crap about the false accusation where my residence was in jeopardy, and then the eviction threat, of which I submitted the documentation from of her confession, signed confession, and threat for further action, which that was it that I'm talking about. But the plaintiff is forced to first deal with this crisis caused by Judge Tina Campbell. For reference purposes only. The plaintiff has clearly won, as the actions by this court demonstrate prima facie, which is why this court are committing crimes to protect the defendant and to keep the plaintiff's evidence from being presented. Document lodged, not filed, per 26 order. Such as the inverted pentagrams, carved in stone and in bronze at Temple Square, the headquarters of the defendant. Such illegal actions by this court, as the plaintiff understands it, is to render a default judgment in favor of the plaintiff. But this requires your honor to step in to make this order official. The plaintiff has already submitted to your honor such motion and order, and merely requires your honor's signature to stop all this deadly criminal nonsense and blatant disregard for reality. If you've been paying attention to the news, you've most likely heard about Rudy Giuliani. And in public, he's insane. He's out of his mind. And he's having a meltdown. But in court, if you've been listening to a news channel that has been quoting from the court, Rudy is telling a different story. He's saying, oh no, there's no fraud. We're not filing a fraud motion. We're not filing a fraud complaint. The election is legitimate. It's for this other reason that we've submitted. Do you see what even he understands? In public, oh yeah, you can gaslight the world. But in the courtroom, you can't do that. My complaint is not just me throwing out accusations against the church and hoping something sticks. The court won't allow that, as they're trying desperately to do anyway. I have the evidence. I even pointed out the obvious one, the inverted pentagram. And now that the virus has escalated, because of their causal situation, and I would put in another brief, if I were allowed, pointing out that her delay from, 26, that was October 29th. We therefore have to go back to October 29th when she gave this order, which was Thursday, and count the number of dead because of her delay over these past 3 weeks. And it's over 200, or almost 200, I think. Almost 200 dead since Thursday, October 29th. I was figuring it last night. But by the time she makes a decision, she just barely allowed the reference purpose of the filing back on November 4th. That brief I just read to you. She is purposely delaying to let the church get away with this. And she is purposely causing further deaths as a co-conspirator. It doesn't take this long to recognize and judge according to the obvious. But it's the church. They run Utah. They threaten the judges. And the judges have to comply, otherwise they will destroy their lives, as they've destroyed mine, as they've destroyed Judge Furse by firing her. Stay tuned.